And now I'd like to kick off the panel discussion by directing my first question to Shardul. You spoke about the amendments to the Indian Arbitration Act. Now, India has been the top foreign user at the SADC, the Singapore International Arbitration Center, in the last few years. In fact, it was the top foreign user in 2013 and again last year. And the trend has been sort of India and China as our top number 1 and 2 foreign user. So we are very popular with Indian parties. Now, how would the Indian Arbitration Act reforms, how would this impact on the seeming preference of Indian parties to use Singapore arbitration?
I think the question of arbitration resolution really depends upon the whole ecosystem of resolution. Whilst India has addressed the question of the Arbitration Act, the mediation principles are still weakly and not that strong. And the court system is still not fully aligned to arbitration and really not interfering with awards. So I do still believe that the Singapore Arbitration Center will have a high level of international commercial disputes till there is experience built up in the courts, which is akin to the court system in Singapore. The process of the amendments which have been introduced in the Arbitration Act, Amendment Act of 2015, really are solving some of the problems which impacted foreign awards in the Indian context. The ability of not granting interim relief as a tribunal because of the reciprocity of judgments versus reciprocity of interim orders. So that's been addressed. The question as to which would be the court, it's been addressed. It's only the High Court now and not other lower courts in India. Issues in terms of the conflicts of arbitrators has been resolved. So all this is really going to impact more arbitrations happening both in India and in Singapore, because I don't believe the system of courts yet in India are fully aligned to arbitration. So I still believe that Singapore will have a predominant share of Indian arbitrations.
Thank you. I'd like to take one question from the audience now, and if I could direct, follows on from what you said about the court system and how important it is to support the arbitration process. When parties try to delay or want to seek to challenge an award, they would naturally need a good, solid court system to go to, the judiciary, in other words. Now, this question to Sachin is, and I read, we require more than 70,000 judges, this is in India, to clear pending cases. Our system lacks the basic needs. Why does this problem even exist in an educated society, and what is the action taken?
Well, it is true. The number of cases that are slowing up our systems, especially in the lower courts and the metropolitan courts, is absolutely phenomenal. In fact, there was a study which said that the number of cases that are now pending in the courts, if all were to be resolved, the Indian GDP would get enhanced by 2%. And I know that the shortage of judges is a long pending problem. And this is much more so at the lower courts. Another interesting aspect is that I'm told most of the cases involve the governments as one party. So it's either the state government or the central government, issues related to land, etc. They go on and on and on. So the Indian judicial system, I think, is well regarded around the world, but there is a consistent problem of delays, and the shortage of judges is a problem that we've been facing for a long time. To be honest with you, I don't know how quickly we'll be able to resolve it, but the fact that we recognize the problem, I think, is a positive indication. And I'm quite hopeful that with new laws that are coming into place, we'll be able to, there's always in India a problem about judicial overreach. So the parliament as the body that makes the law, and the judicial apparatus which looks after the functionality of the law, there has been some sort of acrimony between the executive and the judicial bodies in our country. But I think we are a mature democracy now, and we'll be able to sidestep these issues and not have the overlap that has been there in the last few years. But this is a problem, I think, for us, that we don't have the number of qualified people to take on those challenges at the lower level courts.
Thank you.
Shakwi, may I
This
just
doesn't seem
join?
to be working in terms of not throwing the question out, even though I've done what I'm supposed to do, I think. But anyway, just a note to
Yeah.
the organizer.
May I just add on something?
Sure.
You know, one of the ways is to have a step-down care system, right? For example, in healthcare, not everybody, you will never have enough beds in hospitals. Never. No system will have ever enough beds. So you do need to develop a step-down care system so that the hospitals focus on those that require very high-level specialized care, and then where you do not need that level or intensity of care, you move them down to the next level, and then down to a further next level, right? Healthcare systems work in that order because you will always have the demand outstripping supply, right? So similarly, I think if the court systems can actually also have only the critical cases that go to the courts, and then you have arbitration and out-of-court settlements that will take care of the vast majority of the cases, that sort of a principle actually would work best, I feel, you know. Otherwise, you'll never have enough judges, because the cases, litigation will keep increasing.
Would you like to?
Something
Sure.
about the backlog clearance.
Yes, yes, please.
The backlog clearance, I don't think it is an isolated problem. It has been faced by most of the judiciaries in South Asia. Taking an example from Sri Lanka, in 2011 we did a survey. Since there were so many cases pending, as a Chief Justice, I decided the first step would be do a survey, especially the magistrates and the district courts. We found out as to how many cases are pending and for how long. Taking into consideration the number of years those cases were pending, we thought that we will take up the cases which had been pending for more than 25 years and decided to give priority to those cases. We wanted to have additional judges, and when we say additional judges, what I thought at that time was, it's not mere judges, but the judge should be capable and committed to conclude the case. And there were cases which were very old. Parties had agreed to settle the matter since that matter had been pending for so many years. So therefore, I think in order to clear the backlog, what we should do is, number one, to have surveys and thereafter decide as to what steps we should take.
And my follow-on question to you is, how can Sri Lanka, what steps can you take to further develop arbitration?
Yes, we have a good arbitration center and it has been taking up several cases. I think it is progressing very well. Of course, in the sense that, you know, when there are too many matters, again there is a delay. My concern with regard to arbitration center is that when an award is delivered, thereafter a party which has disagreed with that award could come to High Court. And from there again it can go up to the Supreme Court. So what will happen eventually, even if there is a quick decision in the arbitration center, there could be further delays. The matter might be pending in the High Court as well as in the Supreme Court. So we will have to carefully consider as to what we could do in order to lessen the time that is taken.
Thank you. Question for Pinaki. What business synergies do you think South Asian economies can draw from each other to consolidate their position globally, especially in light of recent developments such as Brexit, for example, giving rise to uncertainties in Europe?
I think it's Brexit. Generally, the kind of statement that we have seen in India is that the Brexit has temporary effect on us. We are insulated from the global, from the Brexit in many ways. But I think one major advantage of South Asia is that because of India and also Pakistan, we have a large domestic market. I think domestic issues are more challenging than the global uncertainties, because global uncertainty has been growing, yet we are growing at 7 to 8% on an average. But if we have to really grow at a faster pace for the next 10, 15 years, I think what is most important is to tackle domestic challenges, and some of the challenges that I have highlighted include reforms like GST, reforms like agricultural marketing. I think we are also not talking about the processes. We have been talking about, in India at least, we have been talking about rate harmonization of taxes, but we are not talking about how the business faces different tax administration in different states. I think we need to talk about harmonization beyond a particular rate, but beyond, but in terms of harmonization of processes, and that could actually foster, that could actually fasten the process of growth and development in a very big way.
Sachin, your views?
I think he's right. The fact is that most of the subcontinent was governed by the British. So what we have in our laws in most countries is a leftover legacy of the British Raj. Last 50 years, there have been enough reforms. I think at least in my country, in India, we've seen there has been forward-looking legislation passed in Parliament, which is now, I think, comparable to the global best practices in terms of legislation. But I agree with Mr. Chakrabarti that it's the process, not just the outcome. So backlogs of court cases pending is one part of it. Other is how do we harmonize and make sure that the different acts that we pass as laws are able to be compatible to each other. We have different law for taxation, different law for companies, different law for income tax, etc., and then the state governments have their own legislation. So there has to be compatibility and interoperability between the state legislation and the federal government's legislation. Once we have that, coupled with a faster churning out of cases, I think the Supreme Courts and the High Courts in India are absolutely impeccable. I have full faith in the integrity and the quality of our judges at that level. But the real challenge, I think, not just in India, but most parts of South Asia, is the qualification and the credibility that is sometimes questioned in the lower courts. And that's a much bigger problem. I think the big ticket items, the big issues at the higher courts are always resolved in the best fashion possible. It's the lower courts and the inability of common person to be able to get justice in due time. And like our former Chief Justice was saying from Sri Lanka, justice delayed is justice denied. So we as a democracy have to work towards ensuring the rights of our citizens and companies and individuals to get justice at the right time, at the right cost. That's very important, but we are working towards it. I think given time, we'll be able to achieve it.
And a final question I'll take from the floor, and this is addressed to Shadul, and I'll try and beam this up, is liberalization of the Indian legal system is long overdue. Do you think India can adopt Singapore's style of allowing foreign firms to practice?
I think there is already a process on in connection with liberalization of the legal profession. Draft rules have been issued by the Bar Council of India. Those are under consideration in relation to the ability to permit foreign lawyers to participate in proceedings in India. So this is very much on the anvil, and discussions are currently on. Whether it will be the Singapore style or whether it will be different from the Singapore style is a moot question, because I think there is a hurry of introducing it in totality. Unlike Singapore, which took 29 years in moving from practicing of foreign law to creating ability for practicing domestic law, India is trying to do it in a very fast track period of probably a year. So this is very much on the anvil.
Thank you. And with that, I think we are just in time. So I'd just like to wrap up and say thank you very much. And would you join me in thanking my panelists today? Thank you. Thank you.